Hi, welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. My name is Melissa Gragg, and I'm a business valuation expert in St. Louis, Missouri. During this episode, we will discuss litigation and arbitration or post-acquisition disputes from a CPA and an accounting expert. We have the privilege today to discuss these issues with Scott Stringer, a fellow testifying expert and arbitrator in Naples, Florida. With the experience that you have, what could an attorney or business owner do differently in the closing agreements or in the closing process to prevent litigation? Because we have to remember that when somebody goes to sell their company, this could be the first time that they've done this. You know, this could be the first time that a buyer has bought a company, you know, and they don't know anything different. And sometimes maybe they will try to cut costs or get, you know, some agreements together that maybe are not as robust. But even then, it's hard to keep them on. So do you have any concepts that maybe they should include in the closing agreements to help prevent some of these issues?
Yeah, I think so, because, you know, it's a lot of times it's funny because we'll go through these litigation, we'll go, wow, if that only been written a certain way. So I had an earn-out provision one time. This had to do with a seller was going to, and again, this is pretty typical. I'm just thinking of a specific one right now. A seller was supposed to make stair-step percentage commission if the net income of the company got to certain levels. So at one level, he got 5%. When he hit that second level, he got 20%, 10% or whatever. And the company didn't do what it was supposed to do, I guess, or didn't do the amount of income they thought it was going to do. And the big issue was the interpretation of what net income was. So you have to really, I would say to attorneys, when you're doing a closing agreement, have an individual, a CPA, or maybe a CPA who's also a lawyer on your team, who's got a significant amount of background in this, to really talk the gap, right? That, you know, it will be earnings before interest, taxes, depreciation, and adjustment on a generally accepted accounting principle basis, utilizing the accrual basis of accounting as typically applied. The more specific you can be in the agreement as to what the earnout is based on, that will help litigation. Almost every earnout situation I've seen, with the exception of fraud, has been a result of just not clarifying the terms.
Yeah, and making gross assumptions, because I've also dealt with some clients that have, you know, talked about earnouts based on revenue, because sometimes getting to that net income or EBITDA or anything from a cash flow perspective, you have adjustments.
Right.
And those are where you're going to start arguing. Whereas if you say we were at 5 million, and if we get to 7 million, I get an earnout, then I think that they've been a little bit, you know, the attorneys and business owners tap us all the time to review buy-sell agreements, but not so much on the closing agreements. And these are complex issues.
Right.
Another thing, I've seen them be inconsistent with fair market value and fair value, or discussing discounts. You know, if there's an issue that comes up, and I think that those are, you know, when you buy out a partner or buy in a partner and things like that, you know, sometimes those are things that can catch somebody up.